Hey, everybody, this is Peter Hafner, Certified Financial Planner and Certified Financial Fiduciary. And today we have Dawn Myszka with us, Elder Care Attorney. And we got some topics we want to discuss. And Dawn, how are you?
Hi, Pete. I'm good. I'm good. The sun is out. It looks like winter has broken and we should be in the warm weather soon.
So I've had a few different questions come up since the last time we talked with various clients. So some of the things I'm going to bring up today are along those lines. But one of the things we're talking about is, are your accounts set up the right way? And that can be really important because it can, slow things down or speed things up, make them more expensive, or make it a lot cheaper to transfer assets. So why don't you tell us a little bit about this topic?
So, if you're talking about whether a checking account or a savings account, credit union account, or even a brokerage account, naming beneficiaries on those accounts can help the transition of those monies when you pass away go a lot smoother, a lot quicker than if you didn't have a beneficiary, and then those assets, those accounts now have to go through probate.
Got it. Hey, and I know if we do not have a beneficiary set up on let's say a brokerage account, a non-IRA account, and then a parent dies and now the kids are inheriting it, it takes days to process that. But it seems like banks instantaneously process these. Is that your experience too?
If you're talking about with a beneficiary designation or not a beneficiary designation.
I'm talking apples to apples, no beneficiary designation with me in a brokerage account versus no beneficiary designation at M&T or KeyBank. In my experience, it seems like the banks just turn these over right away and make the money liquid to the people who are inheriting it really, really fast.
If there are specific beneficiaries listed, then yeah, it's immediate, right away. But no beneficiaries, they'll be told that no, we need letters of, testamentary, or we need your certificate of appointment from the executor. And then okay, now we're not going to have that money in our hands for a while.
Got it. And if there are no beneficiaries, I think other parties can wind up getting involved in this, right?
Yeah, well, hopefully you have a last will and testament in place, because if you don't have beneficiaries on those accounts, and those accounts have to now be controlled by the court through probate, you want to make sure you have a last will and testament directing who your beneficiaries are. If you don't have a last will and testament, then yeah, in that situation, Peter, maybe your second cousins are going to end up with that money. And it was never your intention that your second cousins ended up with that money.
How could that happen? How does it go that sideways?
If you don't have beneficiaries, you don't have a last will and testament, and there's an order of priority under the law as to if the decedent had a surviving spouse, surviving children. If none, then it goes to the parents. There's an order of priority who gets paid, and it could end up to your first cousins, second cousins once removed, maybe nieces and nephews of a predeceased child that you may have never had any relationship with or even know their names. That's why having a will is really important, so that you don't have to, go through that.
Okay. So if you don't have a will, you don't have beneficiaries, there's like a law, there's sort of a succession of where it goes to.
Yeah,
But
exactly.
can it be more arbitrary sometimes where judges are making decisions about what's happening?
No, if there is no will and no specific beneficiary designations, they do have to follow what the law says. The
Okay.
judges can't deviate from that.
All right. And then other than not having a will, not having beneficiaries assigned, are there other mistakes you see people make that along these lines?
Yeah, while they're alive, not having the power of attorney or a proper power of attorney in place so that maybe if they didn't do their proper estate planning and now they're needing to do that, maybe the power of attorney can help them do that. Yeah.
Got it. Got it. So the power of attorney is really important. And we like to get the POA documents on file for all our clients, assigned to all the various accounts. So, because inevitably something's going to happen. And if you don't just outright die, someone's going to need to use the POA to
Right.
help with your assets. Now, for me to do that, though, the agents have to sign the POA document. And when is the right time for the agents to sign the POA documents? Or it probably depends, but if you could tell us about the spectrum of when this should be done.
Yeah, so there are different power of attorney documents. And for the New York State power of attorney, if I was going to designate you, Peter, as my agent under the power of attorney, your powers do not become effective until you've also put your signature on that document, right?
Yes.
So I can literally name you today. I can sign a document saying, oh, I intend, for Peter Hafner to be my agent under my power of attorney. And in order for your powers to be affected, you have to sign the document.
Over the last, up until last year, for the last 15 years or so, we have been collecting the regular New York State POAs.
I see.
Putting those on file. And usually they're all executed. The agent is signed off. It's not an issue. But recently I ran into a situation where someone gave me their POA. It was not executed. And I said, oh, we need to get the agents to sign. And she went back and checked with her attorney, and her attorney did not want the agents to sign yet. So can you tell me a little bit more about that? What would be the thought process behind that?
Well, I don't know. I usually discuss that, with the clients, and then if the client wishes their agent's powers to be activated, then that's up to the client. I don't know why the attorney would tell the client, I don't want your agent to sign it already. I don't understand that.
All right, good, because I didn't understand it either. That's why I want to ask you about it, because it seems like the person you've named as your agent is someone you have the utmost trust in, so you're not worried about something going wrong. And that's the only really thing I could think of is maybe you don't want to give this person the power until they need it. But from my point of view, I want to be ready. I don't want to be creating extra hurdles for people at a time when there's a crisis, there's some kind of health or family event going on.
Right, because that will always happen. And yeah.
That's what POA.
Yeah, and generally, the agent would need the original of that power of attorney document
Yes.
to take it to a bank to have their signature notarized. And if they can't find it among the principal's papers, then there's a big problem now.
Got it. Now, another thing that came up, I have clients in multiple states throughout the country, and you said New York POA.
Mm-hmm.
These POAs, they're different in different states. Tell me a little bit about how that complicates things.
So every state has their own laws.
Mhm.
or power of attorney documents, preparing an execution of a last will and testament, healthcare proxy. So they have their own laws, right? So if you signed, if you're a New York State resident, you signed a New York State power of attorney document, and say you're a snowbird, you go to Florida during the winter time, you're the people in Florida, when they're presented with your power of attorney document, they're going to look at it as it's strange because they're not familiar with their Florida power of attorney documents, like what it looks like. But if you don't have a power of attorney document from Florida, as long as it was properly signed in New York State, your New York State power of attorney, every other state in the United States must and has to accept that New York State power of attorney document as being a valid document. What I tell clients, if they are snowbirds, to avoid any complications, they should maybe consider doing a healthcare proxy and a power of attorney in like their snowbird state, from Florida. Do not do two dueling wills. Do not do a will. If you're a New York State resident and you're a snowbird, you go to Florida for the winter. Don't do a will in Florida because now you got two conflicting, states with their wills. Do a healthcare proxy under Florida law, do a power of attorney under Florida law, have it be identical, at least as far as the persons that you are appointing and the powers under the New York State power of attorney, so that there's no question and no confusion.
Got it. So for snowbirds, you're going to have a New York POA. You're going to have a Florida POA.
Yeah.
You're going to use your New York POA for all your New York business, Florida POA for the Florida business. And really, it sounds like, things can always go sideways, but mostly if you're trying to use a New York POA in a different state or vice versa, it's going to slow things down. And I guess there's more chance of error too, because people aren't used to seeing it.
Well, right, because each state calls that document something different. And, so they're going to look at the New York State document and say, well, what is this? What's an attorney in fact? We don't call them attorney in facts. We call them personal representatives. What's this,
All right. And we talked a little bit about beneficiaries before. What happens if someone wants to make grandchildren beneficiaries? Like sometimes people want to leave $10,000 to each of the grandchildren. Most of it's going to their kids, but they want to do that kind of thing. And what if these kids are minors and then grandma and grandpa die? What sort of trouble have they just invited into their family's lives now?
Yeah, I was just going to ask you because if they're adult grandchildren, they're over the age of 18, not so much of an issue.
Right.
But if you do have grandchildren who are under the age of 18 and you're planning on leaving them money, be it under a last will and testament, or if you designate a minor person as a beneficiary under a life insurance policy or on an investment account, you run into problems because legally they cannot sign documents. They really don't have the capacity to understand those documents. So if you're naming grandchildren or even your own children who are under the age of 18, you pass away, it's going to make it a little more complicated for that minor grandchild to receive their inheritance unless you did planning ahead of time under like your last will and testament, or maybe you created a separate standalone trust because, again, they're minors. They don't have the legal capacity to make those financial decisions, sign documents. So the court may require a legal guardian then to be appointed for those minor either children or for the grandchildren.
And do people usually like legal guardians because they get the extra oversight?
You're right. You have that oversight, but then, if the intention is, well, I don't want my son or daughter-in-law in charge over my grandchild's money.
Yeah.
Well, if your son or daughter-in-law is now the court-appointed guardian of that money, yes, it may be you have court oversight between the son or daughter-in-law and the court, but guess what? They're still going to know, they're still going to be in control over the money to the grandchildren until the grandchildren are age 18.
I never connected that dot. You wind up making the parents in charge of it anyway, and you made it more expensive, and you made it take longer.
And it seems really weird because, a lot of clients say, well, I don't understand, Dawn. My son-in-law, daughter-in-law, they're the biological parents of my grandchildren. I said, yes, I understand that. They're the biological parents, but the court deems it as they need to be their legal guardian. Yeah, more costs, more delay, the court oversight. And then if these are minor grandchildren who do not have a disability, when they turn age 18, if they inherit this, they get this windfall of money at the age of 18, because the law says at age 18, they're an adult, they can get that money. Unless you structure it ahead of time, under a trust, like I said, the standalone trust that you give, you put money in for the benefit of the grandkids, and then you determine the payout. The grandchildren don't get everything at age 18, maybe 20, 25, 30, 40, 45, all of that. But you got to do that planning well ahead of time.
All right. Now, in my experience, when this comes up, it's relatively small amounts of money these people want to leave the grandchildren. And other than setting up a trust to do this, which can be relatively expensive, there's not a good way legally to make sure the money goes to those children. It seems like the best you can do is tell your kids, give them a note. Have this is what I want to happen. You're getting all this. I want five to go to each of the grandchildren as well. Or is there a better way or another way you do that with the people you work with?
So, it depends on the dollar amount that the minor beneficiary is expected to inherit.
Let's stay with small amounts first, then you can talk about other scenarios.
Okay.
So like $5,000 for each for 3 grandchildren, let's say something like that.
So under that circumstance, the court may still appoint an attorney for those minor beneficiaries, but the court may not necessarily need to have the parent appointed as the legal guardian. If it's a small amount, $5,000, the court may allow the estate to pay that money directly to the minor beneficiary. But who's really in charge of that? The minor beneficiary's parent.
Yeah. So what I'm saying is, in the real world where we don't want to invite all this oversight, do you do what I do and just tell them to tell your kids that you want X amount of dollars to go to the grandchildren and leave it to your kids? I mean, that's the way. I don't know of another way that really makes sense to do this when there's minor grandchildren involved.
Yeah, I mean, of course, legally, you can't really, enforce that, and you just hope that the parent really puts a guilt trip on the children, so that the children morally know, hey, this is what I inherited from mom and dad, and I'm going to make sure that I give some of it to the grandkids as I promised.
All right, so that was my one scenario, just smallish amounts of money. But if it's bigger money, you really got to get a trust, right? If you want it to go the way you want it to go, you got to get a trust.
Yes, yes. And with like what we call like a grandchild's trust, the grandparents can set up the trust, for the grandchildren right now. And depends on, what the grandparent wants to do. Does the grandparent want to reap the benefit, of the income from that money that's earned on it, and then that money just gets distributed to the grandkids upon death? It's all of these different scenarios, and whatever, the client wants to do. But that involves like, lots of, discussions with the attorney.
Yeah. I guess there is one other thing, I guess. You could maybe use, I don't use them that much anymore. We used to use them back in the 90s more, the custodial accounts. You could put money in those, then the money becomes the child's once they turn 18 or 21, depending on how you set it up. But then again, someone's got to be the custodian if you're not there to. So maybe that's a good way to do it, though, because the parents can be the successor custodian or.
Yeah. Yeah. But then again, how much money do you trust the 18-year-old then?
Yeah.
Yeah.
All right.
It's always a balancing act. It's moving,
Yes.
moving those shells around and try to put it in the best possible order and everybody's situation is different.
That's right. Nothing's perfect either. It's
No.
trying to get as close as we can. All right. On a slightly different topic, every year the Medicaid income thresholds go up and how much you can keep of assets. Do you have any updates for us on that?
Yeah. So every year, January, February, March, the Medicaid comes out with what the new amounts are for Medicaid eligibility if you go into a nursing home, both for the Medicaid applicant as well as the community spouse, if there is a community spouse. So in 2026, the community spouse who's living at home and their spouse is in the nursing home, the community spouse can have up to $4,066.50 in monthly income. Spouse who's in the nursing home, unfortunately, they can still only keep $50 out of their entire monthly income.
50 per month.
Yeah. And the elder law community, we're trying to get that $50 amount that the person in the nursing home can have out of their income. We're trying to have that increased.
Yeah. That's never.
I don't know if that's going to happen. Yeah, but we're fighting really hard to get that increased from $50. I've been in practice now almost 30 years, and it's been $50 for a very long time that I can remember.
All right. So what this means is if mom's in the nursing home and dad's living in the family home and they had 2 pensions and 2 Social Securities that added up to $8,000 a month, mom gets $50 a month.
Yeah.
Dad gets to keep $4,066, even if some of that income is mom's income.
That's correct.
The rest, the state takes to offset the cost that they're paying.
Yep. The income, I tell clients, income is what it is. We can't really, adjust income, protect income. It is what it is, right?
Yeah. And then RMDs count towards the.
Yep. Yeah.
If people have, what about those annuities where people have a living benefit where they're getting income out of their annuity?
It counts
too.
Yep.
What about beyond RMDs? What if people take out the RMDs and then they take more out? That counts too, right?
It gets complicated.
Okay.
Yeah. It could count as income. It's going to depend on the audit when you're going through that 5-year period and applying for Medicaid.
Okay. Income from a non-IRA, a non-qualified annuity.
Counts.
Who took money out, that counts?
Counts.
Wow.
Yep.
Okay. But if you took
Yeah.
money out of a brokerage account, that doesn't.
It doesn't count, no, because you're just taking money out of a
Yeah.
resource.
Yeah, but
Yeah.
because it's in an annuity, it gets treated differently, even though it's after-tax money.
There's lots of rules for annuities. Yeah.
Okay.
Yeah. So
All right.
yeah, that's the income.
Yeah.
Asset wise, now we're switching it. So the person who's in the nursing home, now they can have up to $33,038. Okay. The spouse who's at home, the community spouse, the maximum, or I should say the minimum maximum that they can have is still the $74,820, up to a maximum now of $162,660. And whether the community spouse gets the $166,000, it depends on again, there's a calculation, there's all of these factors that come in, but the majority of spouses, community spouses, the majority of them end up with only the $74,820.
Really? What kind of things affect it going down?
Well, so the beginning part is the community spouse, 74,820. Then all the other countable assets have to be factored in. And again, there's a calculation and a chart that has to be followed depending on what those assets are. If the community spouse keeps the 166,000 versus the 74,000, if they're a dollar short or a penny short out of the chart, then they keep the 74,000. It's a little complicated.
Got it.
Yeah.
Does that include IRA money?
If the IRA's in payout status, no.
So if someone is old enough where they're required to take distributions, no.
That's correct.
But if they're prior to 73, then it does fall into that.
Yes. Yes.
Okay. So, well, okay. So mom's in the nursing home. Mom and dad got these, let's say they got really big IRAs. The state doesn't want to be paying for mom to stay in the nursing home through Medicaid, because Medicaid is a poor person's program, essentially. So mom and dad got to pay down using their IRAs to pay for the nursing home until they get to 162 to 74, depending on the formula. And then Medicaid starts paying.
If mom and dad were receiving their RMDs from the IRA, you do not touch the IRA. You don't touch the principal. You just
got it.
Count the income.
All right. We are beyond our 30-minute point. So I know when I watch YouTube videos, if they're more than 10 minutes, I have trouble. So we should probably wrap it up. And do you have any other last thoughts before we wrap up for today?
So I just want everybody to remember that estate planning is not just a will, right? Not just a power of attorney, not just a trust. All of those documents, they all work together. They all overlap. Working with your financial advisors, having beneficiary designations in place, that has to all work together for your plan to come out the way you want it to be, which means no probate and Medicaid not touching that money.
Yeah. All right. That sounds like good advice, Dawn. So thanks for joining us again. We'll do this again in a few weeks. And if any of you folks out there watching have questions, send us emails with questions. We're happy to talk about whatever you want to hear about. Send it to service@hafnerfinancial.com. And that's it. Have a great day. We'll see you next time. So long.
Hi, Peter.